please, page 3. And if it's not your first time, or if your case presents special circumstances, such as 1. A child or minor under the age of 18 in the case. In the car. 2. An accident, especially with injury. 3. An allegation that you were speeding while DUI. 4. An allegation that you refused any test. Or 5. If your brother alcohol was double in the legal time. There are ways around the jail time, including alternative sentencing. What should I have done? It's useful to go over what you might have done different, not because you can change what happened in the past, but because you can learn for the future. Obviously, having someone else drive, including a limo, or a taxi, would have avoided the arrest that night. Page 3, 6th line. But for cases involving alcohol, and not prescription or other drugs, it's helpful to know a little but about how alcohol works in the body. Alcohol is a hydrophic, meaning that the molecule attaches itself to water and evenly distributes itself throughout the body. Alcohol affects women more than men, mainly because men have more water contents than women do. Due to higher muscle mass and affects the brain because the brain has a high water content. So here's tip number 1. Make sure you drink water until you're fully hydrated before you drink, and drink water between any alcoholic drinks you have. Tip number 2 is to eat. Eating something before you drink is extremely important. When you consume food, the pylorus or pyloric valve in the bottom of the stomach closes If you have alcohol after eating, the alcohol is introduced into your system at the same rate as whatever the food is in your stomach. If you eat simple carbohydrate like sugars, bread, and pasta, those are processed fats. Complex carbohydrate are processed next to fats, followed by protein and then fats. So eat protein and fats before drink. There is a method that eating after having consumed alcohol can solve the alcohol. Beware, once alcohol is in your system, only time will allow it to dissipate. What you eat after the fact doesn't make a difference.
May I come in?
Okay.
Thank you.
Once you drink, you must be careful to obey all traffic and other laws. This includes having your light equipment, tax stickers, and the equipment working correctly. The police will not be legally justified in stopping you if you don't violate the law. Putting aside your cell phone and concentrate on driving can keep you from being pulled over. If you are stopped, you may be asked for your license and the registration. This is a place where you can get in easily ahead of time. The police will be watching carefully to see if you humble as its information is being handed over. Next, page 4 on the top. Page 4, if you are asked if you were drinking, know that you are not required to answer that question, as it could be self-incriminating. I got asked almost daily what the best response to this question is, and the truth is, it doesn't matter. The police officer will smell the breath inside the car and from the headliner to see if there is an odor of alcohol. The police officer will look at your eyes carefully to see if they are bloodshot and watery. The police will notice if your speech is slant or slow. Page 4, line 7. The police will notice if your speech is slender or slow, and the police officer will observe if you get out of the vehicle, whether or not you are unsteady, run against the vehicle, or have trouble working or standing up. Those observatory will be the primary determination of your potential for intoxication, not your admissions or confessions to drinking. You can answer that however you like, but I prefer that driver's answer. My attorney has told me never to answer that question and leave it at that. If you are asked to submit to field the sublight test, you should politely refuse them. These tests are voluntary under the law and usually don't result in your being let go. They are used to support the officer's conclusion that you were under that influence. Typically, the officer will just start performing field sobriety test. So you will be placed in the uncomfortable position of asking the officer to stop or refusing for the test. Everybody is asleep?
Sure.
Good. Page 4, the bottom line. If you are asked to take a field breathalyzer to screen for alcohol, politely refuse, as this is a field sobriety test and is not necessarily used as definitely evidence of your alcohol level. The law requires, as a condition of your license, that you submit to an eventually test, meaning a breath test under controlled circumstances, or a blood test, or face a 1-year suspension of your driving privilege. So you should agree to take a breath or a blood test. In my opinion, and other attorneys might have a different view on this. You should take a breath test instead of a blood test. I say this despite the violation defense available for blood test for specific reason. First of all, the law is written to measure blood alcohol content. Taking a measure of alcohol from your breath means that it's needed to be converged to a range of what your blood alcohol level should be. That conversion allows for argument, since the breath machine doesn't know, but assumes your lung capacity or how much your body weight or context, etc. Deviate from the standard used. Second, the breath machine is subject to manipulation. More than blood testing drives are. Breath machines are subjected to fermentation, called in dental work, or between teeth, or from someone belching, burping, vomiting, or suffering from acid reflux or jet. Breath machines are also highly sensitive to temperature and atmospheric pressure. Page 5. If at all possible without creating a safety issues, ask for the officer or the jail. Delay testing as much as possible. If you have been drinking 2-3 hours or more before the test, this allows the time factor to work in your favor, burning off alcohol. If you have been drinking 2-3 hours or more before the test, this allows the time factor to work in your favor, burning off alcohol. When you are in front of the breath machine, just as holding your breath warm the air and makes your test result higher, cooling the air makes your breath test lower than it might otherwise be. Remember, breath machines are high sensitive. To temperature, hyperventilating or taking dips, but so the short answer is refuse the field sommelier test, refuse the field breathalyzer, delay as much as possible, and then choose a breath test and hyperventilate before taking the test. Should I fight it? That depends. There is a lot of gray area in between fighting your case and accepting whatever punishment you get. A good lawyer that knows the why. Well and specialize in handling DUI case will be able to analyze your case and come up with the best strategy for your defense. It may be, given the fact of your case, that you have a very good motion to dismiss your case, or a very good chance of winning a trial in the case. It would not make sense to take the first deal offered to you or any deal at all. It may be that after analyzing all the facts of your case, your lawyer will assess that you have a poor chance of arriving at before. It would not make sense to take the first deal offered to you, or any deal at all. It may be that after analyzing all the facts of your case, your lawyer will assess that you have a poor chance of winning at trial. However, even in that situation, you should decide whether or not to take your case in trial based on the deal that you been offered to you to date. If you were offered at alcohol schools plus 30 days in jail, and your lawyer tell you that you would like to take that jail if you went to trial based on experience with the judge, the court, or the facts. You may want to take your case to trial to get bail. That is where you will need to be heavily involved in your case. While DUI lawyer can give you all you need to empower yourself to make the decision about what's the best for you. Measure your risk of each decision involved and agree on a strategy or come up with a long-term solution that you can live with and that meet the goal that you and your attorney originally set up at the beginning of page 6. So sleeping, right? Okay. For you, so that you can feel comfortable handling your case yourself, or can offer to handle court appearance or negotiating a plea bargain for much lower than the full price of service through trial. That really matter is that a lawyer who's especially trained to handle DUI will know of defense strategy that even other attorneys don't know about, and that you would not know about by even after leaving the police report yourself. Just as handling your own IRS tax audit, even doing your own medical diagnosis, you can do it yourself, but you usually get much better result when you expert handle the case for you. How do I find a good lawyer? Remember, no lawyer looks better well their own website. However, there are a few questions You can ask to find out if an attorney is worth your time or other resources. You should be prepared to ask on the phone, via email, or in person the follow question. 1. How many years have you been a practice? This will tell you much about the attorney's potential experience, but also ask what they have done all those years. Many attorneys have done every time of law and have chosen to do DUI recently, but they either don't have the certification or don't have the experience to provide you with the best expertise. Personally, I've been practicing law over 17 years, and I have been handling cases through trial and DUI cases, especially since my first trial. 2. How much experience do you have representing people who are charged with DUI? You should have an attorney's office completely confident that you have spoken to someone you real experience and expertise on DUI law. DUI law is too complex to be trusted to someone that only dabbles in DUI defense. Since I started practicing, I handle exclusively DUI case and take no other type of case. 3. What qualification do you have to handle DUI case? At minimum, most attorneys that field are member of the National College of DUI Defense and the California DUI Lawyers Association. Most attorneys in this field have specific training in breath testing and blood testing and have complete coursework toward those practical tests mastered. Most attorneys in this field have student and structure certification in field sobriety testing. Not only do I hold all those certifications, I also have participated in the National College of DUI. Next, page 7. Defense Trial Skills College at Harvard Law School. On intensive program for DUI lawyer all over the country twice. 4. Who in the office will actually be handling the case and what are their qualifications? This is the most important question you must ask. The lawyer that you might be speaking with or even meet with might not be person who's actually handling the case or will handle a trial if one is necessary. When you demand to speak with the person that you will actually be your lawyer, they discuss your case. This is just another way of giving you the runaround. You do better dealing with your own attorney who know your case and your individual situation well. Many lies with your own attorney who knows your case and your individual situation well. Many large firms hire new lawyers who are unskilled and untrained, but are working at that firm to get their first experience and hide that you having you speak initially with a more seasoned attorney who will not be handling your case at all. The reality of those forms is that the hotshot partner or owner of the firm will never to go court for you, or doesn't simply go to court anyone. You made my full guarantee that I will do all the motion and the communication with you and will be the lawyer in court for you. 5. How many cases have you taken to trial? This is a crucial question and one that separates the man from the boys in DUI defense. Your case just might go to trial to get the outcome you deserve. And it is imperative that the attorney you choose has a significant amount of jury trial experience. In California, the prosecutor can demand a jury trial in the case, just as the defense can. But the prosecutor knows what attorneys are willing to fight to the end for their clients at trial and who isn't, and they prepare to dismiss, reduce, or settle a case if they think there will be a fight at trial. In my entire career, I'm proud to say that I have had over 100 jury trials and have a fight at trial. In my entire career, I'm proud to say that I have had over 100 jury trials and have even received the jury not guilty verdicts in felony DUI cases. 6. Have you ever been disciplined by the state bar? This is simple. You do not want a lawyer with even one bread mace on this bar code or any code of discipline. However, I had any discipline from the state bar, and you are welcome to verify that you entering my state bar number 176398 in the state bar's website. Number 7. What are your potential costs, including experts, investigators, and other costs, start to finish? The lawyer should be completely honest with you about what your case might cost. You want to know what's the cover and what is not, and not be lured with the promise you are unrealistically low fee and costs. The flat fee I charge for legal representation to court it up front and covers the entire case, start to finish. There will not be any point where we run out of money or we have exceeding the hours you paid for and need more. Your case is completely covered by the fee. Even if the case goes on over the year and has a 60 court appearance, you won't pay another $8. What challenge do you see in my case? The lawyer should be able to explain to you what he or she see as the challenges you face and what those could mean on the entire ultimate result. What will be the final outcome of other case? A bad attorney will tell you whatever you think you want to hear up front, but not put it in writing. Next page, page 8. And change completely after they have your fee. A good attorney will not promise you a particular result, because it's always impossible with the limited information up front to be certain how a case will turn out. The California rules of ethics make it illegal for an attorney to promise or guarantee a particular outcome that is up to judge or a jury. So any answer that promises one is dishonest and a postcard. A good attorney will not only tell you that they don't win all their cases, because no lawyer does, but will be honest with you based upon their experience, skills, and the expertise, and tell you what is likely is your case. When you talk to potential defense attorney, tell you everything that you feel is relevant, and then something that may be a minor detail, like what you had to eat, what mental or physical impairment you might have, how much sleep you have, then one medication you might be taking might have all the difference in your case. Most tentatively is honest and open. Your potential by attorney-client privilege, so nothing you may could ever be discovered disclosed outside of your attorney's office or even used against you. Note that, that the attorney can send you mail and promise ridiculously low fee. Plan to take your money and preview quality at the first court date. The National DOI Lawyer website, the lawyer directories take fee from lawyers and only require that the fees be paid to be listed. Same thing with the super lawyers or other magazine article that are made to you. The only qualification is that the lawyers pay a fee and be nominated by someone. How can we get started? I am happy to meet you with a person or do on that telephone or email conversation with you. If done more convenient anytime to go over the fact of your case and sum up with the proposed statement that is individually for your case, please email me info@expertlawyerphone.com or call me toll free, something like that. Okay, today let's finish.
Thank you.
You can go home.
Thank you, sir.
Last class will be this coming Tuesday.
Yeah, next Tuesday.
This Tuesday is last.
Kailangan ko na si MC.
Ha?
Kailangan ko na si MC.
Wala naman kasi. Pero kung hindi na nakabulat. Thank you. Ay, sir.